For reasons mentioned in the judgment, in the order, the petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions.
Highly obliged.
Item 2,
2, 3, 2, ROPSA. In 2 also, the prayer for bail is allowed with certain conditions. The connected IA is disposed of in view of the disposal of the bail application. 1 lakh with 2 sureties.
Highly obliged.
In 3 and 4 also, same orders. Item number 3 and ROPSA 4. Same orders. The petitioners are allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions.
Much obliged, Lord.
That's later. I'd like to mention item number 12.
Item number
Item number 12.
12. Yes.
I have filed affidavit on behalf of the informant, Lordship. Today, I filed one objection also in item number 12. Somehow this is not on record. So let the matter be adjourned for today and fix any other day.
You are for?
Adjournment for item number 9.
Okay. No, have you informed the petitioner?
Already copy has been served.
No, your prayer for adjournment, have you informed?
Yeah,
Or you wait for your turn?
my lord, sorry, item number 9.
Item number 9, yes.
Next week, my lord.
Why?
Yes, the senior counsel, otherwise expert due to that.
Who?
M.
Who?
Kolida.
Okay. Heard Mr. What is your name?
A. Fukon.
Heard Mr. A. Fukon, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. M. Kalita, is in bereavement. Considering the submissions made by learned counsel, the prayer is allowed. Learned additional public prosecutor submits that the case diary has been received. Same may be retained till next day. When we can fix it? After a week.
After a week.
Let this case be listed after a week on a date to be fixed by registry.
Interim may continue.
The interim order shall continue till next day.
Much.
May it please be accepted. Well, item number 11, man. Possibly diaries
Which- Item number 11.
11, man. Diaries possibly.
Heard Mr. N.J. Das, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not yet been received. And he prays for some more time for producing the case diary. The prayer is allowed. Let this case be
27th.
listed again on 27th of May 2024. The interim order shall continue till next day.
Obliged.
item 5,
May I please, your lordship? My lord, this is 430 the bail application, my lord. Your lordship will see at page 14, my lord, operative part. But I am not the name accused, my lord. Subsequently, charge sheet has been filed,
Charge sheet has been filed.
my lord, and my name have been shown as an absconder, my lord, and though no point of time any notice whatsoever has come against me, my lord, that my name has been shown, my lord, at page 22, serial number 8, my lord.
This is a case under
Under, my lord, cognizance have been taken, my lord, that your lordship will see at page 34, my lord. 120B, 419, 420, 465, 468, 471, 326, 270, 313, 304, 511 I received. But my name does not reflect in the FIR, my lord. I'm a petty
Where is
businessman.
the FIR?
FIR, lordship will see the operative part at page 14, my lord. May I read, my lord?
No, not necessary, no.
Small FIR,
Now,
my lord.
now, after the FIR charge sheet has been laid,
Charge bin has been laid down, my lord,
then
showing me as abscond.
have you received summons?
No, my lord, I have not received nothing, my lord. I have approached to the trial court seeking bail, my lord. That was not considered,
Bail was rejected.
my lord.
Where is the rejection order?
That your lordship will see at page 30, it starts, my lord. Case records
You
on-
prayed for what bail?
I asked for the bail, my lord, taking cognizance of so and
No,
so.
but for bail, you have to first surrender before the trial court.
My lord, trial court is that, my lord, the fact is that, my lord, it is a session triable. And documents, all the have been submitted by,
No, it may be sessions tribal, but when you have, where is the order?
order, my lord, lordship
Bail.
will see page 30, my lord.
Reg-
Accordingly, cognizance taken so and so against the accused person, namely so and so, so and so, so and so, Moinul Haq and Janul Ali and Mizanur Rahman. Accused person, namely Akina Ahmed, Sultan Ahmed.
No,
are
the
in-
order rejecting your prayer for bail.
Yes, my lord, I'm coming, my lord. The date speaks for the case that in connection with so and so on behalf of the accused named person. Hard both sides perusal of on the perusal of the, it appears that the registered against the accused persons Mizanur Islam and Mr. Salman and Adil Rahman and Akhtara Shahid al Islam and Mizanur Rahman. Under section so and so 18 of Jubilant Justice Act, the charge sheet has been filed against the accused person Mizanul Islam so and so Rahman, Akita Ahmed, Asid Sultana, Manirul Haq, and Jimabul Ali and Mizanur Rahman so and so. Section 81 of the on the other, on the perusal of the, it seems that the accused Basamat so and so, and she has been judicial custody. After taking the consideration, I am of the view that the materials against the accused persons, as such, bail prayer of the accused persons is rejected. Accordingly, so and so, the bail stands disposed of issue.
No, bail, you're reading page 31.
My lord,
Bail prayer for Akina Ahmad is only rejected because
lord.
she was arrested.
she was arrested.
Question of your bail does not
Does
arise.
not, it is not there.
You have
So
not
what is
yet.
my prayer for your lordship, my lord? I'll face the trial. Lordship, give me some protection, my lord. In particular day, I'll go and appear and seek regular bail. And to that effect, my lord, the Honorable Apex Court also held, my lord. If your
No,
lordship is
what processes are issued against you?
process against issue me, my lord, it is
Whether court has issued summons or warrant.
summons, it seems to be, my lord, issue summons, meaning thereby all mine.
So there is no apprehension of getting arrested.
No, my lord, apprehension is that, my lord, all the offences are non-bailable. And it is a session trial. Fact is that, my lord. The moment, my lord, I approach before the learned court below the CGM court from where someone has been issued. The moment I appear, my lord, court will say, I do not have the jurisdiction because
No,
it
you
is a-
make the court understand that court has jurisdiction.
No,
Why?
my lord, that is true, my lord. It happens, my lord. So my
No.
prayer at this stage, my lord, lordship will give me some protection.
No protection, because you are not under any threat. You will not be arrested. Protection will be given only if you are apprehending your arrest. Now, my query is, what is your apprehension? When court has issued summons to you,
My lord,
then where is the apprehension that you will be arrested?
my lord, apprehension is general. Otherwise, my lord, directly it is not there, my lord. And in the light
When
of
you are admitting that there is no apprehension, how can
no,
I?
my lord, there is an apprehension, my lord. The moment I go, my lord, I'll be put behind the bar. That is guaranteed.
Yes, Mr. Bora.
Madam, my humble submission, Lordship, as part of Sarsi Lordship, there are materials against all the accused persons, Lordship, because he may not be named.
Now,
in the
what is
FIR,
the
Lordship.
maximum punishment for offences against which cognizance have? 313, what is the maximum punishment?
313, my lord,
Whether-
365 is there, my lord. 365, it should be, my lord, 10 years. 420, 468 is the 7 years, 7 years. 270, 313,
326, what is the punishment?
326, 10 years, na 7.
My lord, 313 is my life, my lord.
Life imprisonment, okay. Then
But over and above, it is a session triable.
Hmm.
Lordship only give me only direction, my lord, to appear and seek regular bail, my lord. Till the,
Okay, that protection may be given.
My humble submission, Lordship, assuming, my lord, some non-bailable warrant has been issued against him, my lord.
no,
Then
my lord,
Lordship, we
that
can
is
make-
not, my lord.
But
In the
only
light of-
someone has been issued, Lordship, but now we cannot say that, my lord,
My
when
lord,
the someone is issued, my
Lordship
lord.
will see, my lord, in the SCC 2003 volume 8, my lord. When charge sheet is filed, there is no, my lord. Lordship, kindly have a look at. There
No,
are 7 Lordship.
no. I'll go through the judgment, but what is your submission?
My submission is that, my lord, Lordship kindly protect me, I'll go and appear and I'll seek regular bail. Only that much, nothing beyond that. Whether there is a material or not, my lord, is the subject of the trial. If there is any material, obviously I'll be convicted, my lord. That is the subject matter of the trial. But at this stage, my lord, Lordship has to give some protection. Because, my lord, I made a categorical submission, it is a session trial. And notice and all the things are being issued by the judicial magistrate first class. His power is up to, my lord, 7 years. That is the problem. And to that effect, my lord, our High Court also passed several orders, my lord. If your lordship permit me, I can submit, my lord, those. And there is a very specific provision is there, my lord, reported in 2003 volume 8, my lord, in case of Bharat Chaudhary. Lordship may be aware, my lord, that the 438 bail can be granted, my lord. Even, my lord, charge cognizance is being taken. It's a small paragraph, my lord. Lordship, kindly have a look, my lord, para 7 for a moment.
Read it.
May I read, my lord? Bharat Chandra Chaudhary and another, my lord.
No,
the
Bharat Chaudhary says that
Bharat Chaudhary says, my
that
lord,
438 may be granted, is applicable even if charge sheet is laid,
charge sheet and cognizance is being
is
taken.
taken.
Then also,
That
my lord,
proposition I am not disputing.
my lord.
My only query is, what is your apprehension?
My apprehension is only that, my lord, it is a session triable. Summon and everything are being issued by the judicial magistrate first class. In that case, my lord, he is lacking jurisdiction. Obviously, my lord, lordship, my learned friend has said just now, my lord, 313 is the life sentence, man. In such circumstances, my lord, where to knock the door?
Now on merit, what is your case?
Merit is that, my lord, I am not the name accused. I am a petty businessman, my lord. And police personnel never visited in my house or place. I am the local resident of particular area, my lord. That has not been never visited, and I am not aware of any such cases. Otherwise, I would have taken legal recourse.
Lordship may come to page 28, Lordship. This is a part of the search sheet, Lordship. Page 28.
Yes.
My Lordship may come to, my lord, paragraph number 5, Lordship.
Paraphrase.
My lord, recovered the victim Masuma Begum, whose abortion was illegally performed by accused Jinnatul Ali and Mizanur Rahman. Mizanur Rahman is the present petitioner, Lordship. By making a fake nursing home at the building of the accused Mainul Haq, and later accused Mainul Haq took rupees 23,000 as a source of abortion from Babul Ali, who took Masuma to Mainul's fake nursing home. Recorded her statement under section 161 as well as 164 CRPC. madam. This is the allegation against the person, madam.
Only, my lord, one line is, my
And he
lord,
has been absconding, my
the
lord.
amount has been given to the Janur Ali. He did, my lord, all the thing. If the paragraph 5 is taken into account, my lord, mostly role has been played by the other person, my lord.
Now, how will we
No, my lord, it
Unless-
reveals from the statement itself, my lord. The legal.
When is the next date? When is the
Jinatul
next
Ali
date?
and
fixed?
Maznum.
Next date, next date.
When
next
is the
date.
next date fixed?
Like that, my lord, I am not aware.
Have you received summons?
No, my lord, I have not received any.
Then we have to peruse the records.
Yes, my lord. That
Lordship, what
my
I
lord.
pray, my lord, instead of halting anything, my lord, Lordship just give me direction to appear a particular court, my lord.
No,
seeking
that
regular-
direction is not necessary. If the court has issued summons to you, you can go in compliance to the summons.
No,
You
my
can appear.
problem is that, my lord, which I told your lordship is also aware of that. The moment is a session triable, bail petition is moved before particular court, lacking jurisdiction, my lord. In
But-
that case,
But we, without going through the case diary,
It
cannot,
is LCR, my lord, whatever there is charge sheeted case, my lord, my judicial custody may not be necessary, my lord. What purpose will serve, my lord? I have to face the tribal on this way or that way. Only that much, my lord. It is not, my lord, my judicial custody is necessary for further investigation. It is also not that. It is
so what is your prayer?
my prayer, my lord, to enlarge me on bail, my lord. Lordship kindly have a look, my prayer, my lord, only that much, my lord. I'm not contributing anything against the contention of the charge sheet, my lord, because I have not come for quashing of the affair, my lord. I made a lordship may be pleased to admit the petition for the grant the pre-arrest bill, my lord, to Mizanur Rahman, so and so, in connection with so and so. I sought only pre-arrest bill.
Let the scan copy call for, my lord. We'll produce the scan copy.
Scan copy, what purpose will serve, my lord?
No, whether someone.
I am, my lord.
My lord.
My lord, I am saying, my lord, if someone is been received by me, my lord, obviously I'll go, my lord. But no,
But you have not received.
I have not, instruction is that, my lord, I have not received. So my prayer is only limited, my lord. Court case proceed, let the proceed, the case,
Mr.
J.I. Barber.
J.I. Bordhuyan, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor. This application has been filed by this application under section 438 of the Code of Criminal Procedure, 1973, has been filed by Muhammad Mizanur Rahman, alias Mizanur Haq, who is apprehending his arrest in connection with PRC case number 189/2024, which is pending before the Court of Learned Additional Chief Judicial Magistrate, Morigaon. Stop.
My lord, it is since, my lord, paragraph 11 of my petition, my lord, it says, my lord, the petitioner had already approached session court under seeking 438 bail. The number is being also given.
Where is
there.
that bail rejection order?
My lord, it is not there, but statement is there, my lord.
Then how you are moving this court without a copy of rejection?
My lord, this is the concurrent jurisdiction, my lord. Now, High Court
No, you
knows
have
that.
moved Sessions Court.
My lord, it seems that, my
No,
lord.
that is your petition. It
Yes,
is
my
not
lord.
a question of seeming.
My lord,
You have to submit, you are the petitioner.
my lord,
You are saying that you have also moved an application before Sessions Court
my lord,
and you are before the High Court.
my lord.
Now, what has happened to that petition?
That petition has been rejected. It is annexed, my lord. Page 34. It is annexed.
Where is the,
Page 34. Heard the learned counsel for the petitioner is present. Public prosecutor, the case diary so and so. I heard the board said in connection with 430 filed by the accused Mizanur Rahman. It is there, my lord. Page 34. Mizanur Rahman alias Mizanur seeking pre-arrest bail in PRC corresponding.
so this is a second application under 438.
438 before your lordship is the first.
But under 438 second application.
My lord. And there is no bar also. Having heard the board says operative part 35, having heard
It
the
appears from record that prior to approaching this court, the petitioner had approached the Court of Learned Assistant Session Judge Morigaon under section 438 of the Code of Criminal Procedure seeking anticipatory bail. However, by order dated 4/8/2028, the said application was rejected after perusal of the case diary and connected case records. In view of above, this court is of considered opinion for considering the instant bail application, perusal of the scanned copy of the case diary of,
LCR, my lord, charge sheet.
no, scanned copy of the case diary of Morigaon PS case number 382/2023, as well as scanned copy of the case record of PRC case number 189/2024 would be necessary, hence call for the same. Fixing given day. Fixing 6th, no, before that. Last week of this. The registry to take step for requisitioning
Please, sir.
aforementioned records. Fix this case again on 30th, 35, 31/5.
Item 6.
Worship 438 application, my lord. Delegation under section 120B 406 420 of IPC, my lord. Lecture 1, page 13 is the FIR, my lord. My lord, I am not the named accused in the FIR, my lord. Lecture 1, page 13.
Page,
13, my lord. Lecture 1, page 13.
yes.
My lord, may I read the FIR?
Yes, you may tell me the gist of accusation.
The gist, the FIR contains into two parts, my lord. The first is with regard to allegation that, my lord, the gist of the FIR is that there is a as per the FIR, there is a nexus going on within the dealers that some persons used to purchase the vehicle through finance. Then they, after taking over the vehicle with the help of the dealer, they used to sell it to the third party. And the third party thereafter, as per the FIR, used to sell those vehicles at Itanagar, Dimapur, or any other places, my lord. And as per the FIR is that those persons through whom the loans are transact, my lord, those third party used to give them one solid amount. Then the burden upon the loan and everything is upon those persons. So here in this case is that, my lord, the person's vehicle has been, after the vehicle has been taken away, my lord, the Ezahar was lost. Thereafter, on the basis of that Ezahar, my lord, the SI Rajiv Kolita of the Khelmati outstation, my lord, he has lost the FIR, and the relevant portion, my lord, with regard to the other part, page 15, if my lord takes the last page 15, my lord.
Yes.
My lord, it would
Are
be,
there any co-accused in this case?
my lord, there are many persons named in the FIR. There are 5 persons named in the FIR. I am not among
Whether
them.
anybody has got bail?
My lord, as per my information, my lord, in sessions, they were 439, my lord, not 438. They were arrested and some persons, they got bail by.
Why this has come to before my
Madam,
court, this
madam.
court?
Yes, I don't know, my lord, I have come across, my lord, in the similar kind of FIR, lordship.
No,
Whether
why,
it's a-
why this case has come to this court?
My lord, this is.
Because I am not taking, I don't have criminal bail roster now.
My lord, I am.
So
not-
only those cases will come which have been either rejected by me earlier
My lord, I am not.
or it belongs to same police station where I have given,
Oh.
granted bail.
That might be, my lord. but
Only
I'm
then
not-
this,
My lord, I'm not aware if any bail petition is disposed by your lordship. Other than that, I'm not aware why it has come before this bench.
this should not have come before me.
My lord, I have not seen the file. My lord, may the order sheet reflect. If it is any pending, then the order sheet used to reflect. The registry used to reflect it. My lord, I have not seen the file, but.
Because I don't have this roster. It has to go to the appropriate.
My lord, then. That can
Okay,
be.
but-
Appropriate bench can read the reject is a release. My lord, but the pending is.
এইটোতো আমি ক'ব নোৱাৰিম।
My lord, with regard to any pendency or with regard to
If,
this.
if in connection with this case, any other case was earlier dealt with by me, then I can take, if,
But then, my lord, can this matter be taken after some time? Then I will check the track record of the e-court services.
Okay.
After some time, my lord, of less.
Item 7.
May it please, your lordship. My lord, on 2 earlier occasions, my lord, your lordship was pleased to reject the bail. Of course, quantity involved is commercial quantity. Your lordship should kindly come to your lordship's second order at page 24.
yes.
Rather at page 32. Para 21. However, considering the plea taken by the learned counsel for the petitioners in the instant bail application, the learned trial court is hereby directed to take all measures to dispose of NDPS case number as expeditiously as possible. So having regard to the, my lord, grievance which you expressed, your lordships very clearly provided that this trial should be concluded expeditiously. My lord, I am making this statement, my lord, which we have stated in our petition also. After this order, more than 210 days have passed. Only one witness, that too, my lord, scientific officer, has been examined. It has not progressed.
What is the date of arrest? Your date of
Yes,
arrest?
my lord, as on date, I am on 480 days, my lord. More than 480 days.
In terms of years, what it comes? 1 year?
More than 1 year.
No, whether 1 year, how many months?
12 months, 365 days.
No. You are behind the bars
Since 31/2023.
31, 20,
16 months.
1 year, 4 months. So you have to show me
Yes.
that.
Now, my lord, my submission would be very simple, my lord. Basically, what I will urge upon your lordships, that lordship will strike a balance between my right under Article 21 or Section 436 capital of CRPC and, my lord, 37 of the NDPS Act. Now the question is, the right to speedy trial, that concept which is enshrined in Article 21, can it be fettered by Section 37? That is the issue, my lord. Or Section 436A of the CRPC. Here I'll rely upon two judgments. My argument will be very small, my lord, very specific on the contrary. My case is my right, my constitutional remedy, which guarantees me a speedy trial, it cannot be taken away by any parliamentary legislation. That is, my lord, that is a constituent law. And parliamentary law is a law which is enacted in exercise of the ordinary power of legislation of the parliament. Now, there is a direct judgment of the Supreme Court on this point, my lord. Or my lord may kindly have this judgment. It cannot be fettered. My lord will kindly come to para 8, more or less similar facts, for the facts. MS so-and-so, learned counsel appearing on behalf of the appellant urged that period of long incarceration suffered entitled the appellant to grant of bail. Further, 34 more witnesses were yet to be examined with little or no progress of the trial since the High Court's direction to expedite the trial. More or less, my lord, perimetry of facts. It was also pointed out that the main accused Virender Singh and another co-accused had both already been granted bail by the High Court. Of course, this is not, co-accused, this is not. Co-accused are all bail on the ground of parity. Now, my lord will kindly come to paragraph 19 and 20. Now, court in paragraph 19, my lord, deals with the purport of section 37. Then at para 20, the Honorable Court does the balancing act. A plain and literal interpretation of conditions under 37 should be, that is, that court should be satisfied that accused is not guilty and would not commit any offense, would effectively exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special conditions as enacted under 37 can be considered within the constitutional parameter is where the court is reasonably satisfied on a prima facie look at the materials on record that the accused is not guilty. Any other interpretation would result in complete denial of bail to a person accused of offences such as those enacted under 37. Otherwise, if we give a very strict meaning to section 37, my lord, then the scope of bail would be rather impossible. Now, para 20. The standard to be considered, therefore, is one where court would look at the materials in broader manner and reasonably see whether accused guilty may be proved. The judgment of this court have therefore emphasized that satisfaction which courts are expected to record that the accused may not be guilty is only prima facie based on reasonable reading, which does not call for meticulous examination of the materials collected during investigation, so and so, so and so. Now, up till now, it is okay. Now, this is very important. Grant of bail on the ground of undue delay in trial cannot be said to be fettered by section 37, given imperative of section 436A, which is applicable to offences under NDPS 2. Having regard to these factors, the court is of the opinion that in the facts of this case, the appellant deserves to be enlarged on bail. Lord, I am on this sentence. Grant of bail on the ground of undue delay in trial is not fettered by the provisions of section 37. So the letter of section 37 will lose some relevance, my lord, when your lordships consider a bail on the ground of undue delay in a trial. Lordship will kindly see your last order was of my lord 4/10/2023. Since then, 210 days is over. Only one witness has been examined. I understand, my lord, there are 9 more witnesses. So going by the present trend, my lord, it will take at least 5 years. Does it mean, my lord, I will incarcerate in the jail? Therefore, my humble submission is, my lord, my lord, that's a very tricky argument when we say whether lordship, when lordships will record the satisfaction that I am not guilty. That is too subjective at this stage. But
No.
basically, my lord,
My query is,
yes,
in the order which was rejected earlier, last order,
Yes.
that is 4/10/2023.
yes,
In that case, in para 19,
Yes.
Muslim, what is this? Muhammad Muslim.
yes.
I'm taking FT, I'm sitting in division bench in FT, taking up FT cases, therefore Muslim Mandal is, this is
Muslim Mandal, my lord, I appeared in that case.
Muhammad Muslim.
Para 19.
Yes, that Muhammad Muslim is
Yes.
discussed,
Ah,
and this court came to the finding that it agrees with your submission that the prolonged incarceration overrides
Yes.
the embargo of 37.
yes.
But you have to come to a finding how long for how long you have to be detained so as to come to conclusion that this is long enough.
No, my lord, it's long enough. I'm 480 days, I'm incarcerating, my lord, without the trial being progressed.
What would be the benchmark till,
No, my lord, benchmark
because
will depend upon the facts of, my lord, I
Yes.
don't think it is possible to lay down any
no,
standard.
therefore you guide me.
No, my lord, my guidance would be,
First, listen to my query.
yes,
In NDPS cases, 180 days detention during investigation is
another
allowed,
is permissible.
permissible during investigation. So it is more than general in normal cases.
90 days, 60
It
days.
is double the normal cases. So even if we come to a conclusion that prolonged incarceration overrides the embargo of 37, we have to come to a point that, considering facts and circumstances of this case, this much he has suffered long enough and trial is not proceeding, therefore he is entitled to get bail. So I saw for guidance, we look into the Supreme Court cases,
Yes,
and we could find that for prolonged incarceration, Supreme Court has given bail in only those cases, minimum 1 year, 6 month detention, not less than that. So therefore, though not setting a benchmark, we are seeking guidance that otherwise this bar will come low. It will come to 180 days on some day.
so lordship is, and therefore is of the view that in
The,
those cases where Supreme Court has granted bail, at least for 1.5 years, they were behind the punch.
yes. So you have to show me some case where for
Lesser than that also.
1 year, 4 months, you are behind the bar for 1 year, 4 months.
My lord may have it on some other day. I'll try to find out some judgment. Or else your lordships will maintain a standard for that. It will come after a week, my lord, or wherever.
Yes, if you can show me.
Yes, yes, I'll try.
Okay.
I have followed what has fallen from your lordship.
Because this, this submission that long incarceration overrides, I am agreeable to that.
Yes.
But you have to show me
How to arrive at that figure?
figure. How much is long enough?
In-
That,
What is the standard which has been adopted by the Supreme Court?
yes.
Or maybe some other high courts also. We'll
It
find
would
out.
be good if you can show
No,
Supreme
certainly
Court.
we will try to lay
Let
our
him
hands
show.
to some.
But
Supreme-
my lord, there is a point, my lord, during that period, there has to be no evidence, lordship. If the evidence is going on, lordship, then that will not come. my
No,
lord.
well, kindly see, 210 days, only one.
No, trial is progressing slowly
Slowly, my
in
lord,
this case.
my lord. Only one witness exam.
One,
That too scientific officer.
yes. So otherwise it is not progressing. at-
My lord.
In
It-
fact, especially after your lordship direction,
So you have to show me that period of
I'll do that.
how Mr. K. N. Chaudhary, learned senior counsel assisted by Ms. P. Som, learned counsel for the petitioner. Also heard Mr. R. J. Borua, learned additional public prosecutors. The hearing remain inconclusive. Let this matter be listed. When do you want?
That, maybe after a week, because otherwise I think lordship would be in division bench is like,
After, let this matter be listed after a week,
yes.
on a date to be fixed by registry.
Side রেখে ফেলেন দেরি হবে। Or in that case, no, I think to fix a date may be difficult.
Registry
Yes,
have to
I
fix.
have to follow, because also we have a division bench of lawyers.
Yes, yes.
Deeply.
And you get the item number 6.
Yes, Ms. Borua.
My lord, I have seen from the record of your lordship, there is one case number reflected that, my lord, bail was granted on ground of Arnis Kumar, my lord, 41A services.
Same case.
Same case, my lord, that person was also not named in the FIR, he was arrested, my lord. And the ground was not on merit, it was with regard to the 41A notice, my lord, Arnis Kumar violation of the, my lord has granted. My lord, for a copy, I have some.
Okay, now what is your submission?
With regard to this particular case, my lord, my submit, that is 439 and the merit is different. With regard to this case, my lord, my submission is that I'm not naming the FIR firstly, my lord. And my lord, here some specific persons are named in the FIR, my lord. I'm not amongst those persons, my lord. Specifically, twice names are appeared, my lord, from accused persons. At page number 13 and even in page number 15. I'm not of those accused persons, my lord, naming the FIR, my lord.
Okay.
So, my lord,
Apart from,
and
then why are you
my lord,
apprehending
I
your
have-
arrest?
My lord, I have given that also. Those persons working even in my village, my lord, those persons working in Onachal, even me and some of the elders also, police are apprehending, arrest and searching on the ground that we are working at Onachal, my lord.
My lord,
And
Yes.
my lord, if I come to the facts also, my lord, what I have understood from the FIR, my lord. The FIR, what I have understood from the contents of the FIR is that, my lord, some.
How you are connected with this matter?
My lord, I'm not connected. I have specifically stated, even I have stated in my paragraph that after.
Then why police is searching
But
you?
that is why, my lord, because I work at Arunachal Pradesh most of the time, my lord. And I do come to my.
Only because you are working at
My lord, not
Arunachal.
only me, most of the persons police are searching in my village itself on the ground. I'm maybe for.
Other co-accused are from your village.
That- My lord, they have written Rongazan, different places, my lord, Kutupur, Rongazan, in that way. I don't know, my lord. Yes, my lord, I'm from village Rongazan, Borbil, and here one accused, at page 15, serial number 5, he is also from Rongazan. Rongazan, Borbil, my lord, same village. Same village. At page 15, one of the accused, my lord. Different places, my lord, all accused persons, 5 accused persons. Amongst that, the serial number 5, Nasir Ali, he is from same village, my lord, no, Rongazal, Borbil.
Is from your village.
My lord, he's from my village.
Yes.
my lordship may kindly peruse, my lord, paragraph 4 of the bail application also. This is his apprehension, my lord.
There are 4.
Paragraph 4, my lord, page 6.
that the petitioner respectfully says the petitioner is not named in the FIR, but petitioner is apprehending as police officials came in source of the petitioner. And thereafter, inquiry petitioner came to know about the FIR reflected in Annexure 1. And as such, there is apprehension of the arrest of the petitioner, as such the instant pre-application bail is filed. My lord, even the
Now, my lord, if there is no, my lord, he has not been named in the FIR, so why there is apprehension, my lord?
That can be, my lord, there are cases, this, my lord, that can be, there are many persons who are
Okay, my
not
lord,
named.
I pray to call for the case
Even-
diary, my lord.
My lord, even the case before your lordship, which my lord has allowed the bail, my lord, I have read the content, that person was also not named in the FIR, he was arrested, my lord.
No, he is apprehending because police is searching for him.
My lord, then
There
call
is
for the case diary, my lord.
Okay,
My lord,
let him appear.
My lord,
My lord.
Let him appear before the IM.
Yes, my lord.
Heard Ms. S. J. Borua, learned counsel for the petitioner. Also heard Mr. R. J. Borua, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973 has been filed by the petitioner Razak Ali, who is apprehending his arrest in connection with North Lakhimpur PS case number 56/2024. Corresponding to GR case number 174/2024 under section 120B/406/420 of the Indian Penal Code. The gist of accusation in this case is that Court Para 3 from bail application number 866/24. Learned counsel for the petitioner has submitted that though the petitioner has not been named in the FIR, however, police officials are coming for his search, and it is also submitted that perhaps he is being searched because he works at Arunachal Pradesh, and one of the co-accused named in the FIR, namely, who is from your village?
Nasir Ali, page 15, my lord. Page-
Nasir Ali hails from the petitioner's village. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR, and petitioner is ready to cooperate with the investigating officer. Stop. On the other hand, learned additional public prosecutor has submitted that considering the allegations made in the FIR, perusal of the case diary may be necessary for consideration of the instant bail application. Stop. Hence, call for the case diary. Now, stop. Call for the case diary. Stop. However, considering the fact that the petitioner has not been named in the FIR and from the allegations made in the FIR, nothing has been revealed against the present petitioner. Hence, he is directed to appear before the investigating officer of North Lakhimpur PS case number 56/2024 within 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with North Lakhimpur PS case number 56/2024, he may be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, condition number 1 and condition number 2. Let this case be listed again
5th of June, Lord.
on 5th of June.
Highly obliged, my lord, much obliged.
Item 14 of supplementary is
Where, Lord? I have received a copy of the objection filed by the NCB today. Lordship, in this case, Lordship, the accused person in custody last 4 years, 8 months, Lordship. And one of the co-accused granted bail, his name is Oinam Latikanta Singh. On the last occasion, I have placed before this court. I had
Where-
ordered it at 2024.
Where is the bail order?
Bail order. I have
Do- do
placed
it.
before last occasion on 15/3. Bail application number 533. Not annexed, but I just placed before this court, one copy.
Yes. Yes, now what is the submission?
My submission is that these bails also granted. this- After this, lots of,
When were you arrested?
on same date, Lordship.
8/9/2020, 2019.
Yes, Lordship, may kindly see para
What
3 of
What is
the
what is the period now?
4
one-
years, 8 months,
4 years, 8 months.
8 months. Basically, this bail granted due to the
Long,
prolonged trial and considering the length of detention.
okay.
Lordship, regarding parity, Lordship, my senior already made submission on parity, so that submission will be covered. But Lordship, my submission is, Lordship, contraband recovered from them.
How
From
much contraband was
It's a
Lordship,
commercial quantity, Lordship.
commercial quantity, Lordship, how
now,
it is,
now, what is the stage of trial?
Stage of trial is, Lordship, there are 11 witnesses. As on today, 4 witness examined.
Lordship,
This is reflect on para 7, Lordship. Last line.
Yes,
Lordship, regarding status, Lordship, complaint filed on 28/2/2022. Then charges frame on 31st October 2022. Lordship, this case was splitted up on 19/7/2022. It has been delayed because, Lordship, some of the accused person were absconding, Lordship. That is why it has been delayed. After that, witnesses are coming and duly examined. Last date was 19/1/2024. Last witness was examined on 19/1
no, but
2024.
since 22, only 4 witnesses have.
4 witness only come today.
Lordship, why it has been delayed, I couldn't say.
And both the Latikanta Singh and Sapwan Singh was arrested on same day from the same vehicle, Lordship.
Heard Mr.
U.S.
U.S. Borgohain, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel appearing for NCB. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Swapan Kumar Sinha, who has been detained behind the bars since 8/9/2019 within bracket for last more than 4 years, 8 months, bracket close, in connection with NDPS case number 21/2020. 2020 under section 21C/29 of the NDPS Act, 1985, pending in the court of learned, which court?
Additional district judge,
Additional Sessions Judge number 2,
number 2,
Kamrup Metro.
Kamrup Metro.
Kamrup Metro. The gist of accusation in this case is quote para number 3 from bail application 533/2024. That in para number 3, Abhishek, against the present, there is a term, present petitioner Babu, Swapan Kumar Singhar against the present petitioner. In para number 3, some corrections are to be. Quote para 4. Five, 6. Seven. In para 7, the the period of detention is 4 years, 8 months instead of 7 months. Para 7. Para 8. Para 9. Para 9. Fourth para 8 from bail application number 538/24. Para 8. Para 9. Then next paragraph. Learned counsel for the petitioner has submitted that the co-accused who was arrested along with the present petitioner, namely Oinam Lakhikanta Singh, has already been granted bail by this court on 24/2024 by in bail application number 533/2024. Next, para 11. Para 11, instead of Mr. S.C. can write the name of Ms. M. Deka. M. Deka, learned counsel appearing for NCB. Para 10, 11. Para 10, 11 from 538. Para 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26. From 26 to 33 from 538. Changes আছে অলপ correct কৰিব লাগে. What was the contraband? How
540 kg
of
of morphine. It was reflected para 4, Lordship. 3 and 4 both, or it was reflected.
who is the driver?
Sapan Singh is the driver.
You are the driver.
I am the driver, but it was not recovered from my possession. It was recovered from the secret chamber of the Mudguard, Lordship. It was prepared by the register owner, Lordship. I am the temporary driver, Lordship.
Then para 30, quote para 36 from 533. Yeah, Township Vipa case of 538 and 533. The petitioner is allowed to go on bail of rupees 50,000 with 2 sureties of like amount with certain conditions. This bail application is accordingly disposed of.
Deeply obliged.
Item 8,
May I please, Your Lordship? One of the petitioners are interim bail. They have appeared, my lord.
Item number 8. Yes,
We have received the case then, my lord.
has he appeared?
Yes, my lord, they have appeared, Lordship, they are husband and wife, my lord.
Both of them have appeared.
Only allegation is that, Lordship, they have no returned the amount, Lordship, but my lord, in the statement, my lord, recorded by the IO, they have said that we are paying the loan, Lordship. Allegation is that they have not repaid the amount, Lordship, which was, my lord, granted by the government, Lordship, to the society.
Okay, heard Mr. N. Uddin, learned counsel for the petitioners. Also heard Mr. R.J. Borwa, learned additional public prosecutor. Learned counsel for the petitioners has submitted that by order dated 19/3/2024, the petitioners, namely Jamal Uddin Ahmed and Jamila Khatun, were granted interim bail by this court and with certain conditions, and in pursuant to the directions of this court, both the petitioners have appeared before the
IO.
investigating officer of BOCO PS case number 620/2023 and have cooperated in the investigation. Stop. Learned additional public prosecutor has also has produced the case diary of BOCO PS case number 620/2023 and has submitted that both the petitioners have appeared before the investigating officers and their statement have also been recorded under section 161 of the Code of Criminal Procedure, 1973. Stop. In view of the fact that the petitioners have complied with the directions of this court and have cooperated in the investigation, the interim bail granted to them by order dated 19/3/2024 by this court is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. With above observation, this bail application is hereby dispersed.
I would like to.
Item 10.
Wait, please, your lordship, no? It's a second bail application, my lord.
CD is there.
My lord,
Yes.
diary, is there. If your lordship turns to page 22, my lord, your lordship's order, my lord.
Yes, what has happened?
My lord, only point, my lord, before your lordship, my lord. Lordship may turn to page 23, my lord. Your lordship second page order, my lord. Last paragraph, my lord.
Just a minute.
It is also submitted, the police arrested 4 numbers of aged and innocent person in connection with the said case, and by order dated so and so, the arrested accused person were released on bail on the date of their production itself by the court of learned judicial magistrate first class. Lordship has observed this, my lord. Now your lordship may turn to, my lord, page 19 for a once, my lord, the order passed by the court below, my lord. It starts from page 18, my lord. I'm referring to page 19, my lord. Paragraph 6, my lord. Lordship found it, my lord.
Yes.
My lord, may I read out, my lord? IO SI so and so of this case is absent. Another SI so and so of Mukalmua, yes, is present. CD is produced before me. I have perused the same, which reveals no sufficient grounds for dispensing with the notice as required under section 41A of CRPC. SI so and so who is present today seems to be not fully acquainted with the facts and details of the case. CD reveals no justifiable materials in order to substantiate the ground of arrest as given in the forwarding report. The checklist furnished along with the forwarding is not duly filled. Henceforth, there appears no sufficient materials to necessitate further detention of the accused person. So, my lord, the learned magistrate, my lord, on the date of production, my lord, had allowed their bail, my lord, mainly on the ground, my lord, that section 41A notice, CRPC notice was not served. So in the instant case also, my lord, no 41A of the CRPC notice was served upon the petitioner.
No, but this is anticipatory bail.
Yes,
application.
maybe, my lord, anticipatory bail, but a notice has to be served, my lord, as required, my lord.
Notice is to be served only if. Okay,
So that 41A notice is not served. my lord.
so you will not be arrested if 41A is not.
Yes, but the police is visiting my house, my lord, frequently, my lord. That's the case, my lord. Limited submission is that, my lord. In that case, maybe I may be allowed to go on interim bail, my lord, appear before the IO, my lord. My statement may be recorded, my lord.
Why interim?
Because the police is searching me, my lord.
No,
They
no,
are-
why not final? Why interim? Why I want to.
Oh, my lord, that.
No,
that
I'm
I-
not saying that I will give you final relief,
My lord.
but why you have prayed
No,
for interim?
No, 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 my lord, that is the, my lord, practice we.
Because
used to-
today case diary is there before us.
Yes,
We can either allow or reject.
yeah, I leave it to your lordship, my lord.
It may be rejected also. If,
That is the way of practice, my lord. We usually say, my lord.
yes, Mr.
Only
My lord,
that part,
Earlier,
41A.
earlier rejected lordship considering the case diary lordship. So I have nothing to submit lordship. Already perused the
Oh,
case diary.
earlier
my lord.
rejected.
Earlier
Only
rejected.
rejected, my lord.
10-4.
Then what is the ground?
Well, that's the ground, Mala, 41A, my lord, 41A, my lord. That's why I have read out page 23, my lord. Initial, while submitting my case, my lord, I have read out page 23, my lord. Last paragraph, paragraph 6. my lord. And so for the merit of the case, my lord, admittedly, there was scuffle between the, my lord, with this policeman, my lord. But this police personnel, my lord, came in, my lord, civil dresses, my lord. They were not, my lord, in, my lord, uniform, my lord. So in that
No,
case, my
but
lord,
this was considered on last occasion.
my lord, although, my lord, I have last occasion, my lord, I have submitted this point, this 41 notice from the, my lord, order your lordship, my lord, that is not reflected, my lord.
On 41A, what you have to say?
My lord,
Regarding-
The 41 is as part of punishment prescribed lordship, the 41 notice is necessary lordship. Whether matter it is issued or not lordship, that is the my lord.
What CD says?
The CD says, my lord, they have asked the my lord family members to produce the accused person lordship.
Have they issued 41A notice?
My lord, it is not clear from the case diary, my lord.
No, it will be there in the case diary only. If he is required to be for interrogation purpose, then 41A notice ought to have been issued. Even if materials are against, what is the maximum punishment?
7 years. Promise. I'm giving one. My lord, 7 years maximum, my lord. May extend to 7 years. 3.72%. My lord, here two sections where, my lord,
No, till now you have not been issued any 41A notice. Whether from case diary it appears that 41A notice has been issued and he is refusing
That
to.
is my lord, I'm just going to my lord.
I was going to oppose that fast.
It's not there, Lordship. Only, my lord, there are only 2 pages of the diary, Lordship.
That is updated up to,
My lord, diary is not up to date after 7/3, Lordship.
okay, give me the case. I'll go through the case diary and pass.
Fine.
it.
And moreover, my lord, the
No, you, Mr. Barua, you may make your submission. In a case
My lord.
where maximum punishment is not more than 7 years and the investigating officer has not issued 41A notice, and then the petitioner is having apprehension of getting arrested,
My lord.
will he get the benefit of 41A or not?
And the question is, first and foremost, who is the FIR name accused person, Lordship?
He is the FIR.
Yes, FIR name accused person, my lord. And regarding, Lordship, until and my lord, other cases, my lord,
And,
it is,
and what will happen if once his bail application was considered and rejected? However, nothing has been mentioned in the rejection order regarding the 41A notice.
my lord, second bail application, Lordship may always consider, Lordship, when there is a new ground, Lordship.
They are
Because-
saying that
Yes, my lord.
41A,
He has, my lord, mentioned that 41A notice has not been issued, Lordship, which he has not taken in the earlier bail application.
he's saying that he has taken, I have not written.
submission was.
My lord,
But that cannot be,
Yeah,
from record, it is not, it cannot be.
yeah.
and your lordship, recently one judgment was passed, my lord, where Mr. Kamal appeared, my lord, it's Krishnananda Upadhyay. my
No, but that is it for anticipatory bail or
lord. No,
bail?
that was a regular bail.
Regular bail.
That was a
So
regular
the
bail.
question is, in anticipatory bail application,
Yes, yes.
can you take the benefit of 41A? Can you answer this,
My lord,
this query? In anticipatory bail application,
my lord.
not issuing 41A notice, whether it will help the petitioner?
My lord, probably yes, Lordship.
It will
My lord-
help.
My lord, partial to the, my lord, until and my lord,
Okay.
the other.
Then give
other
me
cases,
the
my lord.
case diary. I'll pass on.
Yes, my
on.
lordship, may peruse the case diary, Lordship, my lord. Only my injury report is also not there, Lordship. Although it is, my lord, 353 is there.
Okay.
Anyway, Lordship may go through the case diary.
I'll pass orders in chamber.
My lord. Only my submission will be, my lord, 353 may attract if the police officer is in dress. Number one ground, my lord. If they belong to a discipline service, they have to go in a proper uniform.
Okay, no, those things I will not consider.
But-
Because this is second bail
Yes, yes,
application.
yes.
Only 41A aspect I will
Yes, ma'am.
consider.
And I will also.
If
try
I
to-
find that it helps you, you will get bail, otherwise you will not. get.
Well, I will also try to find out a judgment and place your lordship, my lord, by Monday itself.
Then I will fix it for delivery of orders on Tuesday.
Can it be on Wednesday, my lord?
Yes.
Tuesday, I have. Yes.
No, for delivery of orders, you need not to
Yes,
be
yes,
there,
yes, yes.
but you supply me the judgment by Monday,
My lord. If I find, if I can find any.
and you can also find out,
My lord, yes.
though you have made your submissions.
So that submission I have made because, Lordship, if it is not issued, Lordship, earlier, my lord, then, my lord, whatever, my lord, in the first rejection order, first bail application, whether that is ground has taken or not, Lordship, that I do not know, Lordship. But from the case diary, my lord, it is, my lord, reflected that, my lord, 41A notice not issued, my lord, although, my lord, the petitioner was searched in his house, and, my lord, family members were asked to, my lord, send the petitioner, produce the petitioner in the, my lord, police station. my lord. That is there reflected from the case diary.
You give me that Krishnananda judgment. Third, Mr. N.J. Datta, learned counsel for the petitioner, also heard Mr. R.J. Barua, learned additional public prosecutor. Let this case be listed for delivery of orders on Wednesday, evening,
It will be 22, my lord.
on 22/5.
I'll try, my lord.
Item 12 and 13.
I am obliged.
No, that objection is not on record. Any other day.
One thing, Lordship,
Madhurjo and Prakash Agarwala are on interim bail.
My lord,
Yes.
I'm not objecting his prayer lordship. So far lordship, first item lordship, Madhuja lordship, although interim order was given lordship. And I submitted the copy before the lordship. I went to the police station, but lordship, IO was on leave. Yesterday only lordship, he has joined lordship, and I have been asked to appear by tomorrow only.
Appeared.
Lordship, I will appear, no, not so long on that, lordship. That's why lordship, up to this
Up to the
week,
case.
yes, sir, up to date, case diary may, or only
Okay, whether case diary is there?
Yes, wait, the case that is my lord. Is up to my lord 19 phone.
Updated case diary would be required. Or he may, you
He has
may,
not appeared, also, then probably after case that will be required.
in second case I appear, but first case lordship,
there are two cases.
my lord, second item. Item 13. Prakash Agarwal,
No, but one case is only there. Two accused persons are there.
lordship,
Case is only one case.
one case,
P-
lordship,
PS case is one.
PS case same.
Yes, case is same.
So two different order lordship, in item number 12 lordship, this is Madhuja Das. He did not.
You are opposing
In both the case.
in both the
Both
cases.
cases.
Heard,
Then the after case that will come.
okay, okay. Heard Mr. A M Khan,
M. Khan.
heard Mr. M Khan, learned counsel for the petitioner in both the cases, separate orders. No? Heard Mr. M Khan, learned counsel for the petitioner. Also heard Mr. What is your name?
AJ Hazurika,
A.J. Hajorika, learned counsel for the
informant.
informant, as well as Mr. R.J. Borwa, learned additional public prosecutor. Learned counsel for the petitioner. No. Learned additional public prosecutor has submitted that the case diary is updated only up to
19 food.
19/4/2023. However, in which case you will be appearing,
Lordship, in item number.
however, considering this,
Madhuja.
considering the facts and circumstances of this case, an updated case diary would be necessary. Stop. Moreover, Mr. Hajorika, learned counsel for the informant, has submitted that though he has filed a written objection, same is not placed on record. In view of the aforesaid circumstances, let this case be listed again on 7th of June. The registry is directed to place the objection filed by the informant on record before the next date fixed. Learned additional public prosecutor is also requested to produce the updated case diary on the next date fixed. The interim order shall continue till next date.
Okay.
In both the cases, separate orders.
Bless.
Item 5960.
My lord, may I please to lordship? My lord, this matter was heard on 10/4/2024. And your lordship posed a query before the prosecution. So whether any material apart from the statements of the co-accused against the present petitioner on record or not. That was already heard by your lordship. Your lordship was about to pass grant bail, my lord. However,
No, how you knew that I was about to grant bail?
my lord, that your lordship
This is wrong submission.
statement.
This may put you to a risk of not getting bail. Yes, Mr. Borwa.
My lord, today, lordship, I could not go to the scan copy, lordship,
Okay,
and I apologize, lordship.
let him go through. Your submission is that apart from statement of co-accused, there is no other material against the
Yes.
petitioner. Let us take it on Monday or Tuesday.
Tuesday, Lordship.
Tuesday, let him go. Heard Mr. H.R. Chaudhary. In both the cases, same submission.
It was tagged by.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor, who has submitted that he could not go through the scanned copy of the case record and seeks some more time to go through the scanned copy of the case record to reply to the query posed by this court in its order dated 10/4/2024. The prayer of the petitioner is allowed. Sorry, the prayer made by learned additional public prosecutor is allowed. Let this case be listed again on 21/5.
Published.